Hello everyone, welcome to this video. In today's video we are going to understand how we can draft a writ petition of habeas corpus under article 226 of Constitution of India. Alright, and under article 226 the writ of habeas corpus is presented to High Court. So we are going to study this format, and you can download this format for free. Link is given in the description. It is for free. Alright, in today's video we are going to discuss all of this format. So let us start. As I have earlier in the starting of this video told you that habeas corpus writ can be filed in High Court under 226. If you want to file habeas corpus in Supreme Court, you can file it under article 32 of Constitution of India. Alright, so these are the difference between these articles. Writ can be issued under both of the article. There is also important thing about habeas corpus is that res judicata does not applies to this writ. That means even if this writ is rejected, you can again file it once or even twice. Alright, even if High Court has rejected your writ of habeas corpus, you can file it again, even in High Court or even in Supreme Court. So there are other writs, certiorari, prohibition. Alright, there are other kind of writs, quo warranto, mandamus. On them res judicata applies, so you cannot file that again and again. But habeas corpus is an exception. Alright, you can file that again. So let us understand this format. First of all, you have to mention the High Court of and at the place where that High Court situated. Alright, in which you are going to file this writ of habeas corpus. Then you have to mention that the jurisdiction of court is original. Alright, then you have to mention the petition and criminal petition number and year. Alright, so basically you cannot fill this by your own. When you file a writ, when your writ is dated, they will provide you this kind of number and they will fulfill this number. Alright, fill that number. Then you have to mention under which article you are going to file this writ petition. Alright, you have to mention this as well. Now in the matter of, you are going to describe the party, the name, son of, age, residence of. Alright, you have to mention all of this, and I have mentioned is through, because the person that you are going to, for whom you are going to file writ petition, is in jail. Alright, because he is detained. How habeas corpus work? Let me just tell you. If there is person A and he is arrested or detained, alright, without any ground, without any reasonable ground, he is detained or illegally detained. Alright, so on his behalf any other person can file writ of habeas corpus. Alright, so if this person is already in jail, this person cannot file writ of habeas corpus, so we need another person who can file on his behalf. Alright, so that is why here through is mentioned, because you are going to mention here the detail of the person who is detained, alright, illegally, and through means the person who is filing on that person's behalf. So here you can mention B and here you can mention A, if we consider that example. And even if that person through which you are going to file is a minor, you can add next friend. Alright, this is not mandatory, you can change that as well. Alright, then you have to mention petitioner at the right hand side, because you are describing that person who is filing the writ, petitioner, then versus, then you are going to make these person as party. Alright, government, state government, home department of that place, district magistrate of that place, and superintendent of jail. Alright, you have to mention the superintendent of jail because the person is already in jail and we are going to file this writ petition in order to liberate that person. Then this is a kind of subject that we are going to file. Alright, the writ petition under 226, praying for issuing writ of habeas corpus. Alright, to respondent 1, 2, 3, and quashing the order which directs the arrest of that person. And alright, and we are praying also from this court that the person who is illegally detained must be released. Alright, and even if there is certain compensation, if it can help, alright, so compensation can also be granted to that person. So from here, once you explain the party, once you explain the subject, you have to mention to whom you are filing: Chief Justice of Honorable High Court and his companion judges. You have to mention the place, alright, High Court of the name of that High Court, and the points that you are going to describe is here. Now, first point that we are considering is that petitioner is filing writ petition under Article 226 of Constitution, alright, and praying for issuing writ of habeas corpus. To whom? To respondent 1, 2, 3. Alright, and what is the object? To quash the order. Alright, order of what? Order of that arrest, and release that petitioner with compensation if required. Alright, so you have to mention all of this. Then you have to mention the petitioner resides where. You have to mention the address. You have to mention that the petitioner who is illegally detained is a law-abiding person. Alright, you have to mention the date from which the petitioner got arrested. Alright, I have chosen here 2 months. You can change it to any desired number. Then place where he is arrested right now. He is detained. Now you have to mention that on the date of getting detention and arrest, alright, you have to mention it here. The petitioner was not informed about the grounds of detention. Alright, you can mention here the days when the person is arrested. Let's say 10 days has been lapsed and no reasonable ground was told to him about his arrest. Alright, so this is a kind of point that you are going to mention. Likewise, I have mentioned here after 10 days of getting arrested, the petitioner was informed, and after 10 days he was informed. Alright, so basically what we are considering, there are certain grounds. Alright, what can be a ground? If you will consider Article 21, alright, 22 of Constitution of India, you will came to know that there are certain grounds on which if a person is going to be detained, that must be followed. What are these? Likewise, if a person is arrested, he must know the grounds. Alright, grounds of arrest. If a person is arrested, he must be sent within 24 hours to nearest magistrate. Alright, if a person is arrested, he have the right to consult an advocate of his choice. Alright, and to provide a phone call so that he can inform to his family or friends regarding his arrest. So these are kind of basic grounds that we provide to the accused. Alright, once the accused is arrested, so we are going to mention that. You can also mention these fact that even if the ground was told to the accused person, that was told in English, and accused was not able to understand. Alright, that the person who is illegally detained was not able to understand because of the language barrier. Alright, so these are the points that you are going to mention. 7th point, you are can mention that petitioner's father is interested in the release. So we are considering that release. Alright, we want the person to be released. The 8th point that you can mention is that the petitioner have no other efficacious remedy. Alright, so what is efficacious? That means there is no other remedy left. Alright, this is the only remedy that is available to the person, and there is no other remedy. If there is other remedy, then you must go for that remedy first. Alright, and after that you can come to this under 226. Alright, so you have to mention it here that there is no other remedy that can be available at this point of time, and only this remedy is available. You can only file under 226, so you are doing that. Alright, you have to mention this fact in your petition. Then the thing that you have to mention is that petitioner have not filed any other petition or proceeding in any court or tribunal throughout the territory of India. So basically you are saying that this is the first petition, you have not filed it anywhere in any court, alright, within the territory of India. And if you have filed your writ petition regarding habeas corpus at any court and then you are again filing it, then you have to mention that fact as well. Alright, you have to mention that fact. Then you are under 10th point, you are saying that the court must pass an order to respondent 1 on dated this, and that the arrest was illegal, arbitrary, it does not have jurisdiction. Alright, these kind of facts you have to mention. The grounds, what are the grounds? You can mention the grounds that because the detention were furnished to the petitioner after prolonged delay. Alright, the grounds was not told in the starting, and grounds were told but after a long period of time, so even that can be a valid reason for filing the writ petition. Alright, and because of petitioner detention in violation of 21 is right to privacy, you can also add here article 22. Alright, these are the grounds under which under article 22 there are certain grounds in subclause 1. You can check that out. Alright, now because of the certain grounds of detention, the petitioner was given in English. Alright, even if the ground were told, they were told in English language, and because of that he was not able to understand. Alright, even that can be a ground. The language barrier can also be a ground. Alright, and then the last point is that because of the ground of detention is very arbitrary and vague. Alright, they does not follow the law or procedure, or they are arbitrary. You can mention that fact. Then the part of prayer come in basic in prayer heading. Basically you are saying that writ of habeas corpus must be issued. Alright, and appropriate direction must be issued to release the petitioner. Alright, and even if the direction is released, if there is any compensation that court thinks fit, that compensation must also be granted to the person who is detained illegally. Alright, and any other relief, you have to mention this fact as well, that if court consider according to fact and circumstance of the case that any other relief can be granted, so court can grant that relief as well. Alright, then you have to mention filed by, to by whom this application is filed, the petition is filed. Alright, and advocate for petitioner, the signature. Alright, then you have to mention the place and date. You can mention, just a second. Alright, you have to mention date and you have to mention place. After that, these are the documents that you require, that once, even if you file petition of writ petition, alright, habeas corpus, So these are the documents. These are basically wakalatnama. Just a second. Wakalatnama. Alright, copies, certified copies, memo of party, list of dates, certificates. So these are the basic documents that you attach with this petition. Alright, so in today's video that's it. If you like, share this video. Alright, and subscribe to this channel for more related video. We will meet you in another video. Till then, goodbye. You can download this format. It is for free. Link is given in the description. Thank you very much.